Case summary. Court case. The Super Servant 2 J. Lauritsen as v. Weissmuller B. v. Citation. 1991 Lloyd's Rep 1. Court of Appeal. Background facts. Claimant J. Lauritsen as defendant. Weissmuller B. v. Plaintiff J. Lauritsen as claimant. Defendant. Weissmuller B. v. Defendant. In this case, the dispute arose from a contract between J. Lauritsen as a Danish shipping company and Weissmuller B. v. a Dutch salvage company. The contract was for Weissmuller B.V. to transport an oil drilling rig from Japan to Rotterdam using one of its two semi-submersible heavy-lift vessels, the Super Servant 1 or the Super Servant 2. The contract stipulated that Weissmuller B.V. had the right to choose which vessel to use for the transportation. Unfortunately, the Super Servant 2 sank before the contract could be performed. Arguments in the court case. Claimant's argument. J. Lauritsen has argued that Weissmuller B.V. was in breach of contract for failing to transport the drilling rig as agreed. They contended that the sinking of the Super Servant 2 did not absolve Weissmuller B.V. from its contractual obligations because Weissmuller B.V. still had the Super Servant 1 available to perform the contract. Defendant's argument. Weissmuller B.V. contended that the contract had been frustrated due to the sinking of the Super Servant 2, which rendered performance impossible. They argued that they were discharged from their obligations under the doctrine of frustration since the loss of the vessel was an unforeseen event that made it impractical to fulfill the contract. Final outcome of the court case. Court's decision. The Court of Appeal held in favor of Weissmuller B.V. The court found that the contract had indeed been frustrated due to the sinking of the Super Servant 2. The key points in the court's decision were allocation of risk. The court examined the terms of the contract and determined that the risk of the sinking of the Super Servant 2 was not allocated to Weissmuller B.V. in such a way that would hold them liable under these unforeseen circumstances. Doctrine of frustration. The doctrine of frustration applies when an unforeseen event occurs after the formation of the contract, rendering the contractual obligations impossible to perform or radically different from what was initially agreed. The sinking of the Super Servant 2 was deemed such an event. Availability of the Super Servant 1. The court considered whether the availability of the Super Servant 1 could have mitigated the frustration of the contract. However, it was concluded that the contract specifically allowed Weissmuller B.V. the discretion to choose between the two vessels, and the loss of one vessel frustrated the entire contract. Key concept implication of this court case. The Super Servant 2 case is a significant example of the application of the doctrine of frustration in contract law. The decision highlights that contracts can be discharged when an unforeseen event, beyond the control of the parties, renders the performance of the contract impossible or fundamentally different from what was initially agreed. Key learnings. Doctrine of frustration. Understand the conditions under which the doctrine of frustration can be invoked to discharge contractual obligations. Risk allocation. Recognize the importance of explicitly allocating risks within the contract to avoid reliance on frustration. Contractual flexibility. Appreciate the role of contract terms in providing flexibility or discretion to parties in the event of unforeseen circumstances.